Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-1 Fiance visas, and a question that has been on the lips of many who deal with immigration on a regular basis, mostly professionals that I talk to, is at what point are we just going to give up the ghost on dealing with petitions for K-1s in the U.S. and go ahead and just deal with it all at an embassy abroad? This has been something I've thought about for years. I really don't understand why either of the K categories, either the K-1 visa or the K-3 visa, why it goes through an adjudication process at the Department of Homeland Security at all. You know, it could easily all be done inside of the embassy, and quite frankly, most of what happens at the embassy and via NVC, it's pretty redundant to begin with. You know, I mean, it's not wholly redundant, let me be clear, but I think it would be a fairly straightforward matter to move the functions, to move the documentation requirements associated with K-1 visa out of the hands of DHS and just move it over directly, all of it, exclusively into DOS's hands. And if you think about it, especially in the case of the K-1 or the K-3 for that matter, once the visa is issued, that's not the end of the story. If that individual wants to get into immigrant visa status, lawful permanent resident status in the United States, they got to go through another process. They have to go through what's called adjustment of status. So to my mind, there seems to be good reason to seriously consider exclusively adjudicating K-1 matters at embassies abroad rather than the current sort of bifurcated process of dealing with Department of Homeland Security only to later deal with the Department of State.